David has been a strong partner of ours for many, many years, and probably one of the best nonprofit attorneys, if not the best nonprofit attorney on Long Island. So
Thank you. Appreciate that. Good morning, everyone. Thanks, Ken, for inviting me, and thanks for that great intro. All right, before we get started, I'm gonna just a couple of quick questions so I get a sense of the room. Who was at last year's presentation? Good. Okay, good. I'll give you a little bit of an update of some of the things we discussed last year. Who in the room is familiar, and hopefully everyone who was at last year's presentation will be able to say yes to this, with the Attorney General's litigation against the Trump Foundation and its directors? Okay. What about the current investigation that the New York Attorney General is, the current investigation that the New York Attorney General is conducting against the National Rifle Association? Have any of you heard about that? That's been in the media. We'll talk a little bit about that. The bankruptcy of Dowling College. Who in the room is aware of that? Okay, good. What about the litigation brought against Dowling's board by the trustee for the unsecured creditors in that bankruptcy? Has anybody heard about that? Okay, good. Well, we're going to touch on that a little. And then last thing is the Healing Arts Initiative litigation that's been around for a couple of years. It was started and it's kind of in limbo right now, but it's a lawsuit against the board of a Queens nonprofit, the Healing Arts Initiative. Anybody heard about that? Okay, good. So we're gonna touch on those things. And I subtitled today's presentation "In the Line of Fire," because what I'm seeing in my practice, and my practice is exclusively representing nonprofits and religious organizations. That's all I do. I'm the chair of the State Bar Association Committee on Nonprofit Corporations. And so what I've been seeing, and it's not a scientific survey by any stretch of the imagination, but I've been seeing more and more enforcement actions and more private litigation involving nonprofits for breach of fiduciary duty. And so today we're going to follow the theme of "In the Line of Fire," the vulnerability of nonprofit boards and nonprofit officers in the current compliance environment. And we're going to look at highlights from select current enforcement actions and litigation by non-governmental plaintiffs, and also media reports. And what you're going to are publicly available materials. And I want to make note of the fact that in most of the instances we're going to be discussing, and I try to stay as close to the language of the complaints as possible so that you can get the flavor of it without me recharacterizing it. But we're talking about complaints and allegations. A lot of these items have not been brought to the conclusion of. Good. Is that better? Okay. And I'll just try to talk louder so people in the room can hear me. Okay. Okay. And let me know if you can't hear me. I'll speak up. Okay. So the two fundamental precepts here are that directors of nonprofits have legal duties, which are referred to as fiduciary duties, and you're going to see this all through everything we talk about today. And that really is the fundamental underpinning of nonprofit law, is that at the end of the day, it's the board of the directors that is responsible through these fiduciary duties. And the corollary to that, of course, is that there can be personal liability to directors for breaching those duties. And that can be a very unpleasant surprise for somebody who steps up and volunteers to serve on a nonprofit board. Good to know that when you start, not when some litigation hits. So the three fundamental legal duties of a nonprofit director: duty of care, the duty of loyalty, and the duty of obedience. The duty of care is that a director has to discharge the duties of his or her position in good faith and with the care that an ordinarily prudent person in a like position would exercise under similar circumstances. That's a lot of language. Basically, it's the board's oversight function. And this is set forth actually in the statute explicitly in section 717A of the New York not-for-profit corporation law. And when you drill down a little bit, what is oversight? At a minimum, it requires familiarity with the organization's finances and activities and regular participation in the organization's governance. So if you're on a board in name only, you are by definition breaching your fiduciary duty because you're not exercising oversight and participation in governance. We'll get to the healing arts lawsuit in a little bit, but that is a good example of the duty of care and the breach of the duty of care being the fundamental aspect of litigation against a nonprofit board. So directors often ask me, well, okay, I have this duty, how can I fulfill it? And I gave you a little roadmap here to how to understand the duty of care and how to begin to comply with it. The first item is in your materials, and I think you've got a very robust set of materials here, and I really encourage you to look through them, including, by the way, their materials on the Nonprofit Revitalization Act. So we won't have time to discuss that in depth, but you have items in your book that can help you through that, and of course I'm available for questions. So right from the start is an Attorney General guidance document, and the subtitle of that is the responsibilities of directors of not-for-profit corporations. And so that is a wonderful how-to guide, and that's a great starting place for boards and officers to understand what their fiduciary duties are. The Adelphi litigation from the late 1990s, a little dated now, but it is a very good resource where the deciding Board of Regents panel that made a decision adverse to the individual trustees of Adelphi was decided under the not-for-profit corporation law, and that also is a very nice roadmap to what the board should have been doing and wasn't doing. Internal controls, and Ken alluded to this, internal controls, policies and procedures are essential for compliance with your oversight responsibility as a nonprofit board member. One of the enhancements, the enhanced fiduciary duties that apply to boards is the audit oversight aspect of the Revitalization Act. And we may have time at the end to talk about that, but if not, that's in your materials as well. And with that, I'm going to move on to the duty of loyalty. The duty of loyalty, and we're going to see how these things play out in some of the litigation that I spoke about earlier in a minute. The duty of loyalty is that a director has to act in the interest of the organization. It requires undivided allegiance to the organization's mission when using a director's position or information that the director obtains. And the way we see this in practice is in the conflict of interest and related party transaction provisions of the Revitalization Act. And you'll probably hear reference to this later in the presentation, but it's been a statement by the Attorney General that New York has the most robust conflict of interest regime in the country, and that's without a doubt true. And that is a hook for lots of enforcement action by the AG, but also lots of private litigation in connection with nonprofit boards as well. Okay, the third fiduciary duty, duty of care, duty of loyalty. Third is the duty of obedience. It's the least understood and most often neglected of the three primary legal duties. And the reason for that is that the other two duties exist in the for-profit world, but the duty of obedience is strictly a nonprofit law concept. And what is the duty of obedience? It's to ensure that the organization complies with applicable laws and regulations and with its internal governance documents and policies. So compliance with applicable laws and regulations is one piece of it. And of course, there are multiple layers of laws and regulations, some of which have been referred to already today in Ken's presentation. And then the other prong of the duty of obedience is compliance with internal governance documents and policies. And key there is the certificate of incorporation, which is basically your charter from the state. It creates the corporation and gives it authority to exist and operate. It's a contract between the organization and the state, and significantly, and this is where you see the certificate of incorporation popping up in breach of duty of obedience allegations, the corporate purposes of the organization are set forth in the certificate of incorporation. And that is critical because underpinning the purposes provision is the concept that a diversion from corporate purposes, no matter how worthy, is a breach of fiduciary duty. And this creates the certificate of incorporation trap, because what happens when organizations form, literally the first document that you have in an organization is your certificate of incorporation. And very often that's filed and then filed with the state and then filed away in a file cabinet. And no one looks at it again, and that creates a huge vulnerability, because you are limited to the purposes that are set forth in that certificate of incorporation. So your assets can only be used for those purposes, and unless you amend your certificate of incorporation following the procedures of the law, any use of assets outside of the box of those purposes is a breach of fiduciary duty and creates a very strong potential for liability, personal liability for board members, because board members are responsible to make sure that assets of the corporation are only used for the purposes set forth in the certificate of incorporation. Another aspect of the duty of obedience is the bylaws and compliance with your bylaws. And Ken alluded to that. I'm going to go through this quickly so we can get to some of the cases, but the bylaws are essentially the contract between the organization and the board. If you've got members, it's also a contract between the board and the organization and the members. And it basically is a roadmap for how the organization is going to operate. The bylaws are rules by which legitimate corporate decisions are made, and they provide the board a roadmap to protect directors from breach of fiduciary duty allegations. There's a bylaws trap that people should be aware of, and that's that by and large, it's rare for the bylaws to be reviewed by the state. So you submit your bylaws to the IRS when you get your tax exemption. You submit your bylaws to the state when you register with the Charities Bureau. But the reality is that almost always they're not reviewed by anyone. So nonprofits often are under the impression that their bylaws have been reviewed and vetted by the state, and usually that's not the case. And in fact, bylaws are very easy to amend. You don't need, in most cases, any regulatory permission to amend your bylaws. And that also is a trap, because it's easy to put very logical provisions in your bylaws that seem to be practical and effective, but in fact, they can be inconsistent with the very strict requirements of the not-for-profit corporation law. So what to keep in mind with bylaws: always follow the roadmap that your bylaws provide. Make sure that the bylaws are consistent with the law. Bylaws should have legal input before any changes are made. And failure to strictly adhere to requirements of the bylaws, or having bylaws that are inconsistent with the law, those are both a breach of the duty of obedience, and that can lead to the undermining of the validity of corporate actions, and there again, potential personal liability for officers and directors. Bottom line here is, I don't think anything, and this is a mantra you've heard from me before if you've heard me speak, nothing that I've said today so far is rocket science, but we're about to see how easy it is when you don't have discipline and you don't pay attention to these requirements to get yourself in trouble. I see a question. So I'm going to repeat the question for the webinar. Is it necessary to amend your certificate of incorporation if you move away from some of the functions in there? And the bottom line is, as long as, so the purposes are the panoply of things you can do. You don't have to do everything in there, but if you're doing something, it's got to be in there. So good question though. Okay, so let's get to some of where the action is. Here's the Healing Arts Initiative lawsuit was filed in April 2016, and you've got the summons in your materials. And basically, here's what it says. And I, again, if you look at the materials that I'm going to reference, you'll see that I stayed very close to the language of the materials, because I didn't want to recharacterize what the various documents said. I want you to see it pretty much direct from the source. So in violation of Not-for-Profit Corporation Law 717, which is the duty of care, and 720, which allows boards to be sued for breaching the duty of care, and other applicable statutory or common law, the directors have neglected, failed to perform, and or violated their duties, including but not limited to their duty to act, and this is literally right from the statute, the duty of care that we talked about before, their duty to act in good faith and with the care an ordinarily prudent person in a like position would exercise under similar circumstances in the management of Healing Arts Initiative by permitting $750,000 to be stolen by 3 former employees of Healing Arts Initiative, by hiring non-independent auditors, by negligently hiring employees, and by otherwise breaching their duties to Healing Arts Initiative. The foregoing actions constitute, among other things, breach of contract, breach of fiduciary duty, and violations of Not-for-Profit Corporation Law 717 and 720. So that just gives you a quick sense of some of the ways that directors can run afoul of their oversight responsibility. And we're about to get some more. And this next slide relates also to a document in your materials. You have the complaint in this lawsuit in your materials. It's in the United States Bankruptcy Court, filed in May of this year. It's in the Dowling College matter, and the plaintiff is the unsecured creditor trustee of Dowling College, and the defendants are highlighted in red, 13 individuals being sued in their capacity as board members, they were the trustees of the college, and also the CFO. And what's the lawsuit about? To recover damages based upon the defendant's waste, mismanagement, and breach of fiduciary duty. Damages being asked for are in no event less than $50 million. The complaint lays out what it suggests are the trustees' responsibilities, so the board's responsibilities. And they were the responsibility to ensure that Dowling's business was carefully managed. And again, think about oversight. Responsible for devising, maintaining, and implementing proper controls, as Ken described earlier, with respect to Dowling's business, operations, and financial affairs, including internal financial controls and operating procedures. The complaint says that the board was responsible to ensure that the business, as conducted by Dowling's employees and representatives, including day-to-day management, complied with all laws applicable to Dowling's industry and to lawful business in general, so duty of obedience. And the board was responsible to ensure and to oversee the establishment, implementation, and maintenance of Dowling's internal financial controls and operating procedures. Quoting directly from the complaint, it is abundantly clear from Dowling's board minutes, and I'm going to stop right there. Minutes are essential. When the Attorney General starts an investigation into a nonprofit, the first thing the Attorney General subpoenas are the board minutes. When we get retained to sue a nonprofit board or nonprofit directors, and sometimes we do that, most often we represent the board, but sometimes we get retained to sue the board, and I really find those representations very valuable because it helps me to understand how to better protect the board the rest of the time. One of the first things we want to look at is the board minutes, and the minutes can either be a map, a roadmap as to how the board fulfilled its fiduciary duty, or it could be a roadmap of the opposite, a roadmap of non-compliance and breach of fiduciary duty and vulnerability and liability personally of board members. So it is abundantly clear from Dowling's board minutes and other documents that Dowling's management did not have any coherent plan to manage its failing enrollment and resultant financial decline, to bolster its failed fundraising, or to pay its enormous bond debt of $57 million. So the ostrich defense, or the Sergeant Schultz defense. If you're my age, you might remember Hogan's Heroes, and Sergeant Schultz was a character on the situation comedy Hogan's Heroes, and his tagline was, "I know nothing, I hear nothing, I see nothing." And that ostrich defense is not going to work under New York not-for-profit law. It's not going to get you anywhere, and your duty of oversight will trump, no pun intended, the ostrich defense every time. So here in the Dowling case, the complaint says that over a period of years, Dowling was faced with declining enrollment, declining revenues, declining assets. The rating agencies were downgrading the rating of its bonds. No fundraising was happening. There was a continual failure to meet budgets. There were issues with its accreditation, and there was insufficient planning. Right. Other than that, everything was fine. Everything was fine. So you'd have to be an ostrich, right, not to see all that. That wasn't a modest set of problems. The software used to manage the financial data was not properly updated, and the resultant financial data was incomplete and unreliable. And that's going to really be a linchpin for this whole complaint, is the lack of complete and reliable financial data. Dowling didn't have any reliable report to assess departmental and academic program financial results, and had an insufficient chart of accounts that did not enable Dowling to adequately conduct its financial reporting and analysis. Consequently, Dowling's board and Dowling's administration did not have the proper tools to evaluate Dowling's financial position or to make informed decisions. Yes. So that's really a fundamental piece. Oh, I'm going to repeat the question. So Ken asked, does misinformation that the board might be getting potentially get the board off the hook? Sometimes, sorry, I can't give you a more direct and clear answer. And if the information the board is getting passes the duty of care test, meaning that a reasonable, prudent person would look at it and say, well, this is thorough, this is current, this is reliable from what I'm seeing from board meeting to board meeting, report to report, that may get the board off the hook if the board had a reasonable basis to rely. But the flip side is true. If the board was on notice that the information was incomplete, if it was clear, if it would have been clear to an ordinarily prudent director sitting in that chair that information is incomplete, unreliable, spotty, then the board's in trouble. And that's what happened here. So Dowling's, and so taking that one step further, I think one of the takeaways from Dowling and why I wanted to highlight it, why I wanted to highlight the complaint, is the oversight duty is not just what's put in front of you on the table. The board has, and if you read the Attorney General's guidance document right from the start, you'll see this. The board has an affirmative duty to seek out and insist on sufficient information. And if the board is not getting timely and sufficient and reliable, detailed information, it's the board's responsibility to insist on that, or otherwise have heads roll and get that information. And if not, the board is breaching its duty. So it's not enough to look at what's put in front of you. You've got an affirmative obligation to get the right information in front of you in a timely fashion. So Dowling's lenders at one point in the chronology recommended an outside financial advisory firm, which reported, among other things, the following. One is that the accuracy of the data extracted from the financial data management software was always in question. So again, now you've got an outside consultant saying in writing to the board, guys and gals, in case you didn't notice this, your information, and they had noticed it, your information is incomplete, unreliable, and always in question. So there's no hiding from that. Management did not believe that it could readily access information to support decision-making. Dowling was at a significant disadvantage by not having access to critical business data to manage key aspects of operations, including enrollment management, student financial assistance, budgets, and cash flow. Pretty significant. Not surprising then, Dowling ran out of money, lost its accreditation, and filed for bankruptcy protection on November 28th, 2016. The complaint Okay. The complaint alleges that the defendant board members and the CFO owed a fiduciary duty to Dowling and had a duty to Dowling and its creditors to carefully manage, oversight, Dowling's business and operations, and to devise, implement, and maintain proper controls with respect to Dowling's business, operations, and financial affairs. Again, controls. Defendant neglected and failed to perform their duties in overseeing the management and disposition of Dowling's assets, thereby wasted, mismanaged, recklessly and negligently dissipated such corporate assets. As a result of all of the foregoing misconduct, Dowling suffered losses totaling at least $50 million, leaving Dowling insolvent and ultimately leading to its financial ruin and bankruptcy. So that's the Dowling complaint, and it's about 90 pages, I believe, but it's well worth reading through and avoiding, in the case of your own organizations, those pitfalls. Question?
Were these charges civil or criminal?
Civil, in the bankruptcy court. Okay, so we're now going to turn to something that isn't an attorney general enforcement action yet. Again, as with everything else, this aspect of the presentation is coming from publicly available materials, and this has been widely reported in the press. And here's an excerpt from CNN on April 29th, 2019. The New York Attorney General's office has launched an investigation into the National Rifle Association. This was reported in numerous media outlets, and according to Tim Mack of NPR, and I think this is a very useful excerpt, and it has implications well beyond the NRA. The New York AG has the ability to oversee nonprofits in the state, and also a unique set of remedies if it finds wrongdoing. If it finds wrongdoing, it could punish a nonprofit by removing their board of directors or forcing them to pay or repay money wrongfully obtained, or even in extreme cases, to force organizations to cease operations or dissolve. The New York Times talked about a stunning internal power struggle, which ultimately led to Oliver North's resignation as executive director of the NRA. And what I see in my practice, what I very often see is that a lot of these breach of fiduciary duty allegations tend to arise in the context of an internal power struggle. And that certainly is the case at the NRA, although there's a little bit of a chicken and egg thing. It's not quite clear whether the AG's investigation led to the power struggle and the internal dissension, or the other way around. Okay, so some of the potential issues in the inquiry that the AG is undertaking, and the AG has been pretty tight-lipped about this. All they've said is that there's an inquiry and that they've subpoenaed some documents. They haven't made any statement beyond that. So most of this comes from media reports. The potential issues, according to some of the press reports, are the use of funds, and this goes to purposes of charitable assets that are set forth in the certificate of incorporation of various entities that the NRA and its related foundation, use of funds held for charitable and educational purposes by the NRA Foundation were used for divergent purposes, including for political activities by the NRA. And the 990s of these organizations reflect in excess of $100 million being transferred from the NRA Foundation that was supposed to be used for charitable and educational purposes to the NRA. And so the belief is that the AG is looking into improper use of those funds in violation of their charitable and educational purposes. And then, surprise, conflicts of interest and related party transactions. According to media reports, there have been multiple transactions, and this also is something that can be pieced together from looking at Form 990 filings, multiple transactions benefiting firms with ties to NRA officials, and also transactions directly benefiting the NRA's CEO. And of course, this was done without following the New York not-for-profit corporation laws detailed and demanding mandatory procedures, and we talked about those earlier, the enhanced fiduciary duties under the Revitalization Act, regarding the handling of conflicts and related party transactions. So according to the Times, the New York AG is investigating transactions between the NRA and its board members, unauthorized political activity, and potentially false or misleading disclosures in regulatory filings. According to Oliver North, the just departed president of the NRA, these allegations of financial improprieties could threaten our nonprofit status. And you'll hear about this probably if we have time later in the presentation. The third bullet point here talks about potentially false or misleading disclosures in regulatory filings. And those filings, primarily the 990s, are really a treasure trove for both regulators, federal, state, and private litigants. When we're suing nonprofit boards, we love looking through the 990s and finding all of the errors, omissions, misstatements. And if you look at Attorney General enforcement actions, and we're going to look at one in a minute, you'll see that they're replete with references to false and misleading filings. And your 990 that's filed with the IRS, if you're a charitable nonprofit, is also submitted to the AG's office as part of your Char 500 and posted on the AG's website, and the AG doesn't like it when information on their website is false and misleading. And so you'll see pretty much universally in AG enforcement actions reference to 990 filings and problematic aspects of those. Okay, any questions before I plow forward? Yep.
Yeah, just one question about Oliver North saying that this might affect our nonprofits situation. Wouldn't he be the one responsible, along with the board, for doing the things, taking the actions that would jeopardize the nonprofit status?
Maybe it depends, and there are pieces of it that he might be responsible for. You know, perhaps I don't know. No inside knowledge. Just I've read the
NRA moving ahead. The other guy, Cox, who was the political guy. Would that be a remedy for the New York State that the nonprofit made these changes when they found out about the things that were wrong?
That change, not to reelect him, because I think that was what happened with Oliver North. That's a tiny piece of all this. And again, we haven't seen this in a petition or complaint yet, but looking at what's in the press, the misuse of funds to this extent, all these related party transactions, this is something that kind of ties into our conversation about the Trump Foundation, which we're going to get to next. Everyone on the board is responsible for that. You've got, as a board member, you've got oversight responsibility, even if you choose not to exercise it. And again, that goes back to the Dowling litigation. Someone not continuing, not being renominated, not being reelected to a particular position, or even somebody being terminated. Good. Okay. So the question was what gave rise to the AG's NRA investigation, and that's the NRA investigation isn't a representative item, because in fact the new AG, as part of her campaign, said that she was going to look into compliance with New York nonprofit law by the NRA. I don't think that's the case with most AG investigations where it's teed up that way. But the kinds of things you mentioned in your question, random audits, whistleblowers, those things come up all the time. And in fact, you should know, and this is not anything, this is not inside information, this is something that the enforcement folks at the Charities Bureau say when they speak publicly to groups, including groups of lawyers, that the 990s are digitized, and there are electronically red flags that come up. They won't tell you which ones, although you could probably figure it out. So that's a big source of AG scrutiny. If there's certain things on your 990 that would cause alarm, then chances are the AG is going to be aware of those. Okay, Trump Foundation. So the AG brought a petition against the Donald J. Trump Foundation and its board. We spoke about that last year at this annual update. And so here's a bit of an update, and we'll get into a little more detail. On December 18th, there was a press release by the Attorney General's office. Today, and I'm quoting, and this there's a number of items in your booklet on this litigation. Today, Attorney General Barbara D. Underwood announced that following a court decision in favor of the Attorney General, and you have that decision in your packet, it's tab 6, the Trump Foundation has signed a stipulation agreeing to dissolve under judicial supervision with review and approval by the Attorney General of proposed recipient charities of the Foundation's remaining assets. But that's not all. The lawsuit, which seeks millions in restitution and penalties and a bar on President Trump and his 3 eldest children, who were all on the board of the foundation. That was the board, President Trump and Ivanka, Don Jr., and Eric. The lawsuit, in addition to millions in restitution and penalties, seeks a bar on President Trump and the 3 eldest children from serving on the boards of other New York charities. This lawsuit remains ongoing. This is an important victory for the rule of law, making clear that there is one set of rules for everyone. We'll continue to move forward our suit to ensure that the Trump Foundation and its directors are held to account for their clear and repeated violations of state and federal law. So last night when I reread this decision, again, it's tab 6 in your materials, I realized that I wanted to read a few lines from it to you. I didn't put in my PowerPoint, I should have, because I think these lines are well worth thinking about. This is a Supreme Court decision, again, tab 6. It's late November 2018, and it was in response to a motion by the respondents, by the Foundation, President Trump, and the 3 Trump children who were on the board, to dismiss the lawsuit. So the court was ruling on the motion of the defendants, the respondents, to dismiss. And the court denied the motion to dismiss. And here's what the court said. I'm going to read to you, and particularly the last sentence I'm reading to you, I think is something that's incredibly important and tells us where this is all headed. So here, the individual respondents, which are the president and his 3 children, were each directors of the foundation and therefore owed fiduciary duties to the foundation under Not-for-Profit Corporation Law, Section 717. As directors of the foundation, the individual respondents were also trustees of charitable assets pursuant to, and then there's a reference to a section of the Trust and Estates Law, and were thus responsible for proper administration of charitable assets, so using assets for their appropriate purposes, as we discussed. As discussed above, petitioner, which is the Attorney General, details numerous alleged acts and omissions by the individual respondents that would constitute failure to discharge their fiduciary duties. These allegations, taken together, adequately state a claim for breach of fiduciary duty. So on that basis, the judge is going to deny the motion to dismiss. But here's the key sentence. The individual respondents, President Trump and the 3 Trump children, do not dispute the bulk of the allegations concerning foundation oversight which underlie these 2 causes of action for breach of fiduciary duty. So I think that telegraphs part of where this is heading. And it's no coincidence that within a couple of weeks, there was a stipulation entered by the respondents and the Attorney General to dissolve the foundation. I think as we saw that there's, last year when we went through in detail, and maybe we'll go through a little bit now, some of the allegations in the complaint, there's pretty clear and compelling evidence of some of this. And it doesn't hurt that after the Attorney General's investigation into the foundation started, the president now president, made restitution to the foundation for certain inappropriate personal expenditures and filed tax returns with the IRS wherein excise taxes and penalties were paid for inappropriate self-dealing. So it's kind of hard to argue that nothing happened here when you've got those sorts of admissions and filings. Questions, anybody? Keep going. How am I doing on time? Am I all right so far? Good, thank you, thanks. Okay, so at the heart of this litigation by the Attorney General is that the Foundation's board existed in name only. And you have here direct cites to the petition, paragraphs in the petition, which are in your material. The foundation existed in name only. The board existed in name only. Foundation board members failed to exercise their fiduciary duty to provide oversight and control. You're hearing those words a lot today, oversight and control of the organization for at least 19 years. The board hasn't met since 1999 and does not oversee the activities of the foundation in any way. The board has not set policy or determined the direction, operation, or acts of the foundation. In the absence of a functioning board, Mr. Trump, Donald, ran the foundation according to his whim rather than the law. So the three Trump children are on the hook here for damages. And so what's interesting is they're on the hook for millions of dollars of damages and throw in some unpleasant reputational implications. Three of the four directors, the three children, unquestionably had no active role in the foundation, but they're on the hook. And that again drills home. Yep.
So in all of these cases, you talked about the Trump and several other cases. To what extent does directors and officers insurance kind of come into play in these sorts of things, or because they did things not following or kind of breaching their duties, are they at a point where the directors and officers insurance is kind of not in the mix?
That's a great question. And so on the subject of D&O insurance, every nonprofit should have it and make sure you have it in adequate amounts and talk to your insurance broker about increasing the amounts because most of the risk for the insurance company is in the first million. And so so subsequent millions are way cheaper than the first million. D&O insurance can save the day and sometimes get you off the hook. But if you've ever seen your D&O insurance policy, it's probably 80 or 100-page document with lots of fine print. And it's really going to come down to, are there exclusions or carve-outs in the policy that you may have run afoul of in a particular situation? So it's really hard to tell without seeing the details of the policy. I guess the takeaway is make sure you have D&O insurance because it can really save you, number one. But number two, don't put yourself in a position where you have to be using it because it doesn't always pay at the end of the day. The D&O carrier may have an ability based on provisions in the policy, based on how far outside of the law your activities are. And the corporate purposes issue is an important one because one of the, inevitably in a D&O policy, there's something that says that you need to follow the law. Well, if you're operating outside of your corporate purposes, you're giving an insurance company a nice basis to potentially disclaim liability because the law says you can only operate within your corporate purposes. So by operating outside, you're putting your D&O coverage potentially at risk.
So in a lot of these cases where from a law perspective, the AG or somebody else went after these organizations and they were found to be not in compliance, does that mean in essence they were breaking the law or they were just not in compliance? To what extent does a negative finding in one of these constitute breaking the law from an D&O perspective, or are they just not compliant? Or again, one of those.
Yeah, I think that's more of a gray area that's going to depend on the specifics and the language in the policy. Yeah. Question. So the question is: a bank employee serves as a board member and a treasurer. The bank provides an annual grant to the organization, and is that a conflict of interest? something that the organization's attorney should look at. But as a general matter, the conflict rules and the related party transaction rules are focusing on money going out of the nonprofit, not into the nonprofit. So if there's a grant and nothing more, then the conflict of interest rules probably wouldn't come into play. However, if, for instance, the organization used the services of that bank, then for sure there's a potential conflict of interest, and so that's something if you think about some of the related party transaction items that we're talking about today in some of these case studies and examples, they involve payments by the organization, and that's really what the focus of those rules is. So I'll punt on that, and not my decision anyway. I'm not in the Charities Bureau enforcement section. And I'm sorry, the question was, just to repeat it, the one that I punted on, why doesn't anybody go after the Clinton Foundation? Okay, so back to the PowerPoint. So again, the fact that the 3 Trump children, who by definition had no involvement, that's the allegation against them. The fundamental allegation is they had no involvement. The Sergeant Schultz defense, ostrich defense, is not going to work. They're still responsible for everything that happened here. And why? Because of their duties as a nonprofit director under New York law. So I'm going to sail through some of the breaches of fiduciary duty because they're pretty straightforward and they're in your slide. Basically, lack of oversight, allowing the foundation's charitable assets to be misused. And here's some interesting specifics, and I think Ken alluded to some of this before. And this is how some of the basic nonprofit governance geek compliance obligations that people tend not to put enough attention on come back to bite you in the context of an internal dispute or an enforcement action or litigation, because all of those things are going to then be uncovered in the minutes and in the 990 filings, and they're going to be used as evidence of breach of duty against the board. So in the Trump Foundation, the board played no role in approving grants and failed to obtain annual reports. There's got to be an annual meeting every year. It's required under New York nonprofit law, and the board has to have an annual report, an annual financial report, and if you've got members, they need to receive that annual financial report. It's specified in the statute. Specific information has to be given to them, and it can't be more than 6 months old, which is why June is my busiest month, because all of my clients who have year-end financials try to squeeze their annual meetings in before the end of June so that their financials are not more than 6 months old. The foundation failed to adopt a conflict of interest policy, even though New York law since July 2014 required the foundation to adopt such a policy. Again, going to Ken's presentation, the foundation didn't have an investment policy, even though New York law required it to have such a policy no later than 2010. And Ken also mentioned investing your money in money market accounts. And here, direct quote, although in recent years the average monthly value of the foundation's assets was over $1 million, the foundation kept its funds in a money market account earning negligible interest. None of this is rocket science. The Trump Foundation board decided not to pay attention to any of these items, and it's certainly coming back to bite them in a big way. We talked about false filings, basically the 990s, and this is, again, a core element of the Attorney General's petition here, making false statements and filings with the Attorney General, engaging in self-dealing, wasting charitable assets, violating the Internal Revenue Code, expenditures to influence the outcome of an election, which is what happened in the Trump Foundation context. All of this is abdicating the board's responsibility to comply with the law, the duty of obedience. So we unpack that in terms of the 3 basic fiduciary duties. So unpacking slide, that slide, we see that making false statements and filings with the Attorney General that's duty of obedience. Engaging in self-dealing, duty of loyalty. Wasting charitable assets, duty of care. Breach, 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 breach. Violating the Internal Revenue Code by, among other things, making expenditures to influence the outcome of an election. You violated federal law, but at the same time, because of the duty of obedience, violating federal law caused a simultaneous violation of state law. You abdicated all responsibility for ensuring that the foundation's assets were used in compliance with the law. That breaches both the duty of care and the duty of obedience, so lots of bells are ringing here. The foundation is little more than an empty shell that functions with no oversight. There's the O word again, by its board of directors. The foundation, which does not have any employees, delegated its operations to the accounting office of the Trump Corporation, which is a business entity. Board members failed to exercise their fiduciary duty, and that's the key here. You can't hand it off. It's not tag, you're it. It's not, well, we thought other people were taking care of it. We didn't look at the 990 filing. I signed it, but I didn't review it because my accountant and my lawyer signed off on it. None of that works. It's your fiduciary duty to provide oversight and control. And you're going to see that over and over again in all of the Attorney General enforcement actions and private litigation. Okay. Mr. Trump caused the foundation to enter into transactions in which he had a financial interest without obtaining authorization from the board. And this is some language that I want to highlight for you. Or determination by the board that the transactions were fair, reasonable, and in the foundation's best interest at the time of the transactions. So these words appear in the statute. If you've got a related party transaction, which is essentially a financial transaction between someone on the board or an officer and the organization, or someone's business, a board member or family member's business, or a business they have financial interest in, the board has to follow certain very demanding procedures to vet that transaction. It's not enough for the board to review the transaction and approve it. That didn't even happen in the Trump Foundation case. But even if they had, they still would have breached their fiduciary duty unless they adopted a resolution that used what I refer to as the magic words. These magic words are in the statute. Because it's a financial transaction with an insider, the board must, under the law, make a determination, say affirmatively that the board has found that the transactions were fair, reasonable, and in the organization's best interest at the time of the transaction. So those are magic words that the board has to include in its resolution. Good. Okay. Okay. So I'm gonna forward ahead. I'm going to show you just quickly in my last couple of minutes. This is a picture. It's slide 56. It's a photo that appeared actually in the Attorney General's complaint, and it's a photo of Donald Trump at a campaign event giving a $100,000 donation from the foundation's checking account to a veterans charity, and the mixing of the political and the nonprofit are very clear here just from looking at the check. The check is a foundation check, but it's got the logo of the campaign. It's got the "Make America Great Again" slogan of the campaign on it, and it's got the border and the stars that were used as the campaign's trademark. That's something obviously that you can't do, and that's something that is a core part of the AG's complaint. And I think with that, I think that is in the complaint too, or maybe it was in the press coverage. But that was one of the. And if you look at slide 59. It talks about some of the self-dealing and related party transactions, including lots of payments. And this is a good place to end because it goes to a couple of things we've spoken about. So you see a list here on this slide of payments to various charities. So you might say, well, what's wrong with the foundation paying money, the Trump Foundation paying money to some other charity or foundation. Well, the purpose of the foundation is to make charitable contributions, but not in the service of Donald Trump's businesses, and that's what happened here. And so there's a very clear roadmap here, and these are not speculation or they're allegations, but these in fact are the things that restitution was made for, and excise tax filings and penalties were paid to the IRS. So pretty much it's clear that these things happened and they were violations of the law. So I think that's a good place for me to stop. Thank you for your attention. Do I have time for a question? One question. Yep. Okay. So I'll repeat that conclusion to the question, which I think is a good way to summarize it. Is this kind of conduct by private foundations typical or atypical? And from my experience, it's certainly atypical, and this is particularly egregious. But there are plenty of examples, some public, some not, of foundations not being in compliance and not following the laws. And the thing that I would flag for everybody again is that you've got these annual filings with the IRS and the Attorney General that are designed to tease out some of this information and that are digitized. And so there's a track record, and there's a paper trail there with potential red flags. And worse than a red flag, of course, is misstating or omitting information that would be a red flag. So there's lots of pieces in the current compliance environment that can get you into trouble, even if you're not nearly as egregious as what the Trump Foundation clearly was.
Your advice would be to kind of stay away from private foundations.
No, I have lots of private foundation clients, and they're run very well. So that's and I'm going to conclude there, but that's a great place to conclude. What you should do as a board member, the first thing you should do as a prospective board member is read right from the start, which is right in your packet of materials that I gave you, the AG guidance document, guidance for board members, what they should look for even before they get on a board and what they should look for after they get on a board. So the answer is not to stay away from board service, but the answer is to scrutinize very carefully what your duties are and how the nonprofit that's asking you to serve on the board is complying with those duties, and whether or not they're getting you into trouble. Thank you very much.